to welcome members, staff, guests to the first meeting of the Water Board for calendar 2018. Thank you all very much for being here. We've got a number of items to cover on the agenda today, but I think it's going to be a fairly quick meeting. I hope so. At the end of the meeting, we're going to have, the very last agenda item is an executive session, and we will ask that everybody leave for that, but it is the last agenda item on the agenda. So when we reconvene, we're simply going to adjourn the meeting. So if you choose to leave as we go into the executive session and not return because you have other things to do, then please go do those things, because the meeting will be essentially over when we go into the executive session. Mr. Rodriguez, would you call the roll, please?
Yes, sir. Chairman Carney,
I'm here.
Member Davis, Member Fernandez Ketchum, Member Freed,
Present.
Member Golden,
Here.
Member Sue, here, Member Shaw. We have a quorum, Mr. Chairman.
Mr. Secretary, thank you. Thank you very much. First agenda item then is the approval of minutes of the October 23rd, 2017 meeting. The members have had a chance to review those minutes. Are there any suggested revisions or corrections? Comments?
Move their adoption, Mr. Chairman.
Thank you very much, Mr. Golden. Is there a second?
Second.
Thank you, Adam. All in favor, please indicate with aye.
Aye.
As there are none opposed, the minutes are adopted. I thought I'd do a bit of a preface before we get into the meeting, just to set up what we're going to try to do here today. Many of you know this, certainly most of you know this, but I thought for those who are not aware, in May of 2016, the board adopted a rate increase of 2.1% after public hearings in the 5 boroughs. We also adopted a deadline of December 31st, 2016 to comply with and receive benefits, and then receive benefits under the Multi-Family Conservation Program. A number of individuals immediately thereafter filed an action in the New York Supreme Court challenging the validity of the board's approval of the 2.1% increase and seeking to enjoin the board's decision. The court's decision upheld plaintiffs' challenge, effectively suspending the implementation of the rate increase that we approved. A New York appeals court affirmed that decision. We elected to appeal that decision, the appellate court, and took the case to the state's highest court. The Court of Appeals, New York Court of Appeals, reversed the lower courts in December 2017, last month, effectively permitting this board to implement immediately the rate increase approved in 2016. Also on that date, the board approved setting a deadline of 31 December 2016 for participation in the Multifamily Conservation Program. We elected to suspend that implementation, the implementation of the deadline, while we sorted out what the implications of the case would be for us. So that essentially was the state of play until December 19th, when the Court of Appeals reversed the decision of the lower court. So that's where we are now. Prior to this meeting, we held a public hearing. A public hearing was held, in which we took testimony. The 2 people who testified are with us in this meeting, Mr. Signorelli and Mr. Weiss. Thank you for staying. And we heard certain objections that they had raised, and we intend to address those in this meeting. That's the setup. That's pretty much all I have to say about that. We're going to go into the meeting, but what will transpire during the meeting is affected by the case that was ultimately resolved last month. So the next item on the agenda is an update on the system's financial condition, and we will turn to Joe Heron to get us there.
Thank you, Mr. Chair, board members. So we wanted to give a financial update in light of the winning of the New York State Appeals Court and the affirming of the 2.1% increase that would have been effective for July 1st of 2017. So what and do we, for the slides? Okay. Oh, there we go. What I first want to open with before I call up Ed Marcus, who is the systems rate consultant from Amawalk Consulting Group, is to go through and make a point that has been made previously, is that with the elimination of the rental payment on the water and sewer infrastructure by Mayor de Blasio, that's delivered $1.1 billion in cash savings to the system through fiscal year 2021. So that's been, a big help in terms of being able to keep the strength of the system going. I'll turn over now to Mr. Marcus to be able to speak to the other elements of the financial statements that have been part of the assessment done for the 2.1% rate, the rescission of the 2.1% rate increase.
Okay, well, there are a number of points on board there. The first is that we're about 6.5 months into fiscal year 18, and the system's in a very strong financial position. Revenues for the year are in line with plan, about $25 million over plan on $2.5 billion in collections, so about 1%, just terrific. Debt service costs for this year are expected to be about $95 million less than previously projected, thanks to lower interest rates. The rollover of cash from fiscal year 17 was actually about $76 million higher than what was expected. So we actually expect that even with the payment of the bill credit, or I should say the application of the bill credit, which will be a reduction to revenues, that by the end of 18 we'd have a slightly higher cash balance than what was projected in the original plan. So the system's financial condition is strong, and the 2.1% rate increase is not required to meet the board's budget obligations.
Are there questions for him?
Just thinking about future years as well, kind of the multi-year impact of a rate freeze, are there any anticipated implications on rollover for next year or cascading impacts of not increasing the rate this year?
Well, we'll be assessing as part of the fiscal year 19 rate setting process, not only the potential rate for fiscal year 19, but also for subsequent years as well. But right now, because of the fact that we do have the bill credit is a one-time effect, so it's not a permanent reduction to the revenue base, which is very helpful. And also the additional cash that we have coming out from 17 to 18 and the debt service savings, so we actually expect to come out of 18 with a little bit more money than we even had before. So long term, we don't see this as having a significant impact on the future cash flows, but we'll be reassessing everything in the coming weeks as well. Thank you.
And if I could add to, Member Freed's question, is that, as Ed just said, we are still going through for fiscal year 19 our assessment of what the, debt service needs will be, what the revenue projections will be, and what the new needs will be. So we thought it was much more fiscally prudent to propose to the board to rescind the 2.1% and come back basically in April, so almost just about 2 to 3 months from now, to go with the full rate setting process that will fully go through and lay out for the board first, then go through the 5 public hearing process, and then come to the board in May with the rate proposal that will be considered, and then you can take action from that point as well. So we want to it's been a little off kilter for the past 2 rate setting seasons, so we want to get back onto that normal basis of rate setting for the next upcoming fiscal year. Any other questions, Mr. Chair, members, for Ed or myself?
Not here, sir.
Okay. So what I would like to next turn to is this is what I just walked through. The multi-conservation program. So the multifamily conservation program, MCP, is a flat rate billing program for multifamily properties with 4 or more units. Eligible properties must be metered with wireless transmitting devices and make water conservation improvements. Approximately 10,000 properties that were transitioned onto the MCP rate in 2012 have yet to provide evidence of compliance with the program terms. The FY 2017 rate schedule stated that properties that do not provide evidence of compliance would face a 10% additional penalty rate on top of their MCP charges after December 31st, 2016. Since the FY 2017 rate schedule was enjoined in June 2016, the penalty was not assessed. The proposal is to amend the December 31st, 2016 deadline to December 31st, 2018, and to assess the 10% penalty rate to properties that do not provide evidence of compliance beginning with the next annual bill cycle, that is, payments due July 31st, 2019. DEP would immediately begin enhanced outreach and engagement with affected properties to ensure that they can meet these compliance terms. I know there were some questions raised, Mr. Chair, at the hearing. I don't know if you want to reiterate those or.
The principal question had to do with one set of questions had to do with the MCP and the existence of whether there exists clear, demonstrable steps that a party would take in order to qualify. And one of the questions raised was whether DEP is consistent in its application of the MCP requirements, qualification requirements.
And to those points, we do plan to, as I noted at the end of it, we're going to have an extensive outreach program, which will include both internal communication within DEP as well as out to the community of both the homeowners, account holders, to understand how the program is going to work. Understand that the program is encompassing those properties that don't have either a meter and haven't taken measures to implement conservation measures. A lot of properties have taken those measures, have a meter already, and those properties that are already in the process of taking measures to put in place conservation measures will be given leeway in terms of when they will be expected to have those in place. So we want to be, very cognizant, I think, as was raised by the constituent during the public hearing, of those concerns, and we will make sure that there are going to be consistent application and clear guidance to all, parties there. That's why we wanted, as we did this last, for the fiscal 2017 rate setting, we gave ourselves that to the end of the calendar year. In the same instance here, that'll give us sufficient time to have that outreach and conversation with the community and take into consideration what their unique needs are going to be. There may be some that are across multiple properties, there may be individual cases that we'll have to take into consideration. So we're going to make sure that our ombudsman process within the Bureau of Customer Service is stood up and that they can be directed and helping all those that are affected by this so they can smoothly transition over. So we're going to be taking, it's something that's been in the works for a number of years, and many out there in the community have been anticipating that this program is coming. So we think a lot of people have already taken action, and now we want to just make sure that those that have not have sufficient notice and can start taking immediate steps that need to become into compliance.
So to be clear, if at the end of 2016, a ratepayer who is making an effort and can demonstrate that that effort is material to comply with the requirements of the MCP, the fact that that ratepayer has not completed whatever the prerequisites are will not mean that they are denied access to the program.
Correct. They would not be levied with the 10% charge at that time.
Okay, and you all will develop some mechanism, and it may be a bit amorphous, but as concrete as you can make it, to ensure that our people who are responsible for making the 10% decision are clear what substantial progress means.
That is correct.
Okay, all right. Are there other questions?
I have a question. Thank you very much for your presentation. You mentioned the ombudsman and the Bureau of Customer Service. Would it be your suggestion for those members of the public who are concerned about the prospect of inconsistent application of standards or have worries along those lines as were expressed in our earlier proceeding, that they should reach out to the Ombudsman and the Bureau for Customer Service? Is that the best route for members of the public to address that potential issue?
Yes, that would be one of the outlets as well. And as I said, we'll also work extensively with, one of the parties that's, we're going to probably partner closely with, would be Housing Preservation and Development, since there are a lot of properties that are under their auspices that will fall into this category of those that are still in the MCP, but they haven't come into compliance.
Thank you.
Also, thank you for the presentation today. I think it's always important to have Water Board and DEP leadership here to present the financial state and the proposals that are happening, so appreciate your attendance and presentation today. Also, while I'm supportive today of the extension for the deadline, we just want to stress that the deadlines are important, both to make sure people have predictability and know when to take action, and also not to penalize those who do, and make sure that they can get the benefit and that there is an incentive for others. So I appreciate very much and support the increased outreach efforts and targeted efforts that are happening, and want to stress the need to do that over the next few months to ensure that when the deadline does approach in the future, that those who have not yet complied have done so, not because they weren't aware of the program, but because they haven't done what is required of them, and if they did so knowing what they should have done, and would be less likely to support another extension if we condemned it. We made a very goodwill and aggressive effort to reach those people.
Thank you, Member Friedman. And I would add that we will, in that interim period, we'll have a number of board meetings, so I would, make the suggestion that we could report back to the board as to how the program is progressing as it moves along.
I was going to ask whether you would do that for us, Jim. Thank you.
Yeah, I anticipate. Are there any further questions? If not, I'll turn it back to the chairman.
Then I guess it's mine.
Okay, thank you.
Thank you, Joseph. The next agenda item is the adoption of the amended fiscal year 2018 annual budget. The matters which have transpired between our adoption of the most recent budget and now have led to the need to amend that budget. And the amendments actually reflect in major part Ed's presentation, the suggestion that DEP and the Water Board will have sufficient funds if we maintain the status quo to do the business we have to do. That budget is in your packet of information. Have you all had a chance to review it? Are there any questions about it? Okay. Hearing none, may I have a motion, please, to approve the budget as amended?
May I just ask if,
Yes.
for procedure, just for good practice, to read the resolution as it relates to the rate before we vote on it?
You like me to do that?
I do like it. Just so the public has a chance to hear what we're voting
Yes,
on.
of course.
There are copies of the resolutions on here as well.
I just had it.
This would be the resolution.
I've actually marked mine up. I'll do this as quickly as I can. It's fairly long out here. Whereas pursuant to a financing agreement dated as of July 1, 1985, as amended between the New York City Water Board and New York City Municipal Water Finance Authority and the City of New York, the board is required to adopt or amend an annual budget. And whereas on May 18, 2017, the board adopted an annual budget for the fiscal year commencing July 1, 2017, which is fiscal year 2018, which was based on the rate schedule first effective July 1st, 2015. And this is the FY 2016 rate schedule. Very, very confusing. I'm sure everybody's following. Whereas a December 19, 2017 decision by the New York State Court of Appeals in the matter in the case reversed a lower court order and put into effect the board's rate schedule first intended to be effective as of July 1, 2016. And whereas the decision created the need for the board to re-examine its annual budget and to amend the annual budget as necessary, which was the motion I was calling for. Whereas the board has received an amended certification from the authority, and its turnout is in the back of the room, dated January 19, 2018, regarding the authority's budget for fiscal year 2018, reflecting the authority's expenses and estimated aggregate debt service as such terms are defined in the authority's general revenue bond resolution. And whereas the board has received an amended certification dated January 19, 2018, from the Director of Management and Budget of the City of New York regarding the amounts the city reasonably anticipates it will have expended during fiscal 2018 in connection with the operation and maintenance of the water and wastewater systems as described in, and it goes on to describe the lease, term of the lease provisions as amended between the city and whereas the board has received certification from AECOM USA, consulting engineer pursuant to a certain section of the lease to the effect that amounts certified by the city for costs incurred or to be incurred in connection with paragraphs A and B of that lease agreement. And whereas the board has reviewed the budget for the board's own anticipated expenses for fiscal 2018 and combined with the proposed expenses for the authority and the city, the board has prepared an annual budget for the ensuing fiscal year, the annual budget, whereas the board has received certification from Amawak Consulting, thank you, Ed, the rate consultant to the board regarding the amended forecasted cash flows and anticipated revenues for fiscal 2018, and the last whereas, the board has reviewed the rate consultant's amended forecasted cash flows and the board's amended annual budget for fiscal 2018 and has determined that such provision for anticipated expenditures is reasonable and appropriate to enable the board to exercise its powers and carry out its purposes in accordance with the New York City Municipal Water Finance Authority Act. It is therefore resolved that the amended annual budget for the board for fiscal 2018, a copy of which is attached here too, is hereby adopted. May I have a motion?
So moved.
Thank you, Adam.
Thank you for humoring me.
Second.
Thank you very much. All in favor, indicate with aye.
Aye.
As there are none opposed, the motion carries unanimously. Our newest member is now here. She was delayed on the train. Evelyn, it's good to have you. Thank you for being here. The next agenda item and final substantive agenda item is the adoption of the rate schedule effective July 26, 2018. Members have all had a chance to read the resolution, but I will read it into the record. Well, first of all, are there any questions about the resolution? Anybody have? Okay. All right. This one is probably 3 lines shorter. Whereas the board is authorized pursuant to certain section of the Municipal Water Finance Authority Act to establish in accordance with another section fees, rates, rents, or other charges for the use of or services furnished, rendered, or made available by the water and wastewater system of the City of New York. And whereas, in accordance with certain sections of the Act, a public hearing concerning certain proposals regarding water and wastewater rates and charges was held immediately prior hereto, and a summary of the hearing and all written statements submitted by January 25th have been received and reviewed by the board. And whereas, in accordance with certifications received from the New York City Municipal Water Finance Authority with respect to the authority's amended annual budget for the fiscal year commencing July 1, 2017, which is the 2018 fiscal year, the city, with respect to the amounts which the city reasonably anticipates it will expend during FY 2018 in connection with the operation and maintenance of the water and sewer system, and rental payments requested from the board, if any, and AECOM USA, consulting engineer, with respect to the reasonableness of the city's certification of certain expenses, the board has on this day adopted and amended an annual budget for FY 2018. And whereas a December 19, 2017 decision of the New York State Court of Appeals in the matter of whatever the case, the name of the case, reversed a lower court order and put into effect the board's rate schedule, first intended to be effective as of July 1st, 2016. And whereas the FY 2017 rate schedule included, among other other things, a 2.1% increase over the rate that was in effect for the fiscal year commencing July 1, 2015. And whereas based on the requirements set forth in the board's amended annual budget for 2018 and the testimony and statement submitted at the aforementioned public hearing this morning, the board is determined to rescind the FY 2017 rate increase in its entirety back to the originally intended effective date of July 1, 2016. Shall I read that again? And whereas the board has further determined that the billing policy proposal to extend the compliance grace period for properties that were automatically enrolled in the multifamily conservation program from December 31, 2016 to December 31, 2018, and various clarifications to existing policies and procedures set forth in the board's revised water and wastewater rate schedule effective January 26, 2018, as publicly noticed, should be approved and as recommended by staff. It is therefore resolved that the 2.1% rate increase adopted by the board in the FY 2017 rate schedule is hereby rescinded in its entirety. And it is further resolved that the water and wastewater rate schedule dated January 26, 2018, a copy of which is attached hereto, which reflects the rescission of the 2.1% increase, as well as the extension of the grace period for compliance with the multifamily conservation program, as described above, is hereby approved. May I have a motion? Thank you, Adam. Is there a second? Second. Thank you very much, Adam. All in favor, please indicate with aye. Aye. Are there any opposed? The motion carries unanimously. That was the last substantive agenda item. May I have a motion, please, to go into an executive session to discuss various matters related to litigation? So moved. Thank you, John. Is there a second?
Just a second.
Thank you, Andrew. All in favor, please indicate with aye. Aye. We are in executive session. Thank you all for coming. Thank you. Let the record reflect that the board has just come out of an executive session during which no action was taken, no decisions made, other than to return to the public session.
Okay.
Is there any other business to come before this board? Hearing none, may I have a motion, please, to adjourn? I move to adjourn, Mr. Chairman. Thank you, John. Is there a second?
Second.
Assuming there will be no objections, we stand adjourned.